If you think prenups are just for celebrities or billionaires, you're missing out on one of the most practical financial tools available to Australian couples. And that misconception could end up costing you tens of thousands of dollars if your relationship doesn't work out. I know that nobody gets married expecting it to fail, but here's the reality. Nearly 1 in 3 Australian marriages end in divorce. And when they do, the average cost of sorting out property settlements through lawyers can easily hit $20,000 to $30,000 per person, sometimes much more. I'm John Boy from JB Solicitors. Over my 17 years in family law, I've helped hundreds of couples through property settlements, both the messy, expensive ones and the clean, straightforward ones. Today, I want to show you exactly how binding financial agreements work in Australia, when they make sense, and why they might be one of the smartest financial decisions you never thought you needed to make. Let me start by clearing up the biggest misconception. When most Australians hear prenup, they think of Hollywood divorces or ultra-wealthy families protecting generational wealth. But that's not what we're talking about here. In Australia, we call them binding financial agreements or BFAs. And they are not just for the super rich. They are for anyone who wants certainty about how their finances will be handled if their relationship ends. Think of it like insurance for your relationship's finances. You don't buy car insurance because you plan to crash. You buy it because accidents happen. And when they do, you want protection. Let me tell you about 2 clients I'll call David and Sarah. Both doctors, both sensible people. When they got together, David owned an investment property worth about $400,000. Sarah inherited $80,000 from her parents. They talked about protecting these assets, but decided it felt too transactional for their relationship. 8 years later, they separated amicably. No drama, no fighting, they just grew apart. By sorting out their finances, this was a different story. David's investment property had grown to $750,000. They bought a family home together. Their super balances had both increased significantly. What should have been a straightforward split became months of negotiations through lawyers. By the time they reached a settlement, they'd spent over $28,000 in combined legal fees. And here's what really frustrated them. A properly drafted binding financial agreement at the start of their relationship would have cost them about $6,000 total. They could have saved over $20,000 and months of stress by spending a few $1,000s up front. Now, there are actually 3 different times you can create a binding financial agreement. Type 1, before marriage or moving in together. This is your classic prenup. You're planning to get married or move in together and you want to set the ground rules for how the finances will work if things don't work out. This is often the cleanest option, because emotions aren't running high and you're both thinking clearly. Type 2, during the relationship. Maybe you didn't think about it initially, but circumstances have changed. One of you has inherited money, started a business, or your financial situation has shifted significantly. You can still create a binding financial agreement during the relationship. Type 3, after separation. Even if you've separated, you can use a BFA to formalize your property settlement without going to court. This can be much faster and cheaper than consent orders, especially if you are both reasonable and want to avoid the court system entirely. Now, I understand that bringing up a BFA can feel awkward. Nobody wants to plan for failure when they are planning a future together. But here's how I explain it to my clients. You are not planning for failure. You are planning for clarity. So let me break down the practical benefits, because this isn't just about saving money on legal fees. Benefit 1, complete control over your settlement. With a BFA, you and your partner decide how things get divided. You are not leaving up to a judge who doesn't know anything about your situation. Want to keep your family business separate? Done. Want to protect an inheritance for your kids from a previous relationship? Sorted. Benefit 2, speed and certainty. When a relationship ends, the last thing you want is months of uncertainty about where you'll live or what you'll be left with. A BFA gives you immediate answers. No waiting for court dates, no lengthy negotiations. Benefit 3, privacy. Court proceedings are public. Anyone can walk into a courtroom and listen to the details of your financial life. BFAs are private agreements between you and your partner. Benefit 4, preserving the relationship. When you have a clear agreement in place, separations can actually remain amicable. I've seen couples with BFAs who are still friends after their relationship ended because there was no financial conflict to poison the well. This is especially important when there are children involved. And benefit 5, avoid stamp duty on property transfers. Let's say you own a property worth $800,000 and you need to transfer it to your ex-partner as part of your settlement. In New South Wales, that could trigger stamp duty of over $30,000. But if the transfer is done under a properly structured BFA, you can avoid that stamp duty entirely. Based on my experience, BFAs are particularly valuable in situations where one or both of you are bringing substantial assets into the relationship. They are also valuable if you own a business or if you're in a profession where your income is likely to grow significantly over time. Now, BFAs aren't just handshake agreements. They are strict legal requirements that must be met, or the agreement won't be worth the paper it's written on. So let's run through those. The first is that both parties must get advice from separate lawyers. Your lawyer needs to explain what that agreement means, what rights you're giving up, and what the advantages and disadvantages are. They then provide a certificate confirming they've given you this advice. Second, both parties must fully disclose their financial position, assets, liabilities, income, everything. If someone hides assets or lies about their financial situation, the agreement can be set aside later. And third, the agreement must be entered voluntarily. If someone was pressured, threatened, or doesn't understand what they were signing, a court can invalidate it. So that should give you a general overview of how BFAs work. The reality is that most couples will never need to rely on their BFA. It'll sit in a drawer for decades and hopefully never be looked at again. But for those who do need it, it can be the difference between a clean, amicable separation and a drawn-out, expensive legal battle. Now, BFAs aren't right for every couple. If you're both young, have minimal assets, and similar earning capacity, the cost might not be justified. But if you are bringing significant assets into the relationship, you're in a high-earning profession, or you've been through a divorce before, it's definitely worth considering. The key is getting proper advice early. Don't wait until you're planning a wedding or moving in together to start thinking about this. And definitely don't try to do it yourself with a template you found online. The legal requirements are too specific and the consequences of getting it wrong are too serious. If you're in a relationship where a BFA might make sense, or if you're curious about whether your specific situation would benefit from one, it's worth having a confidential conversation with someone who understands both the legal requirements and the practical implications. We can review your circumstances, explain your options, and help you understand whether a BFA would be a smart investment for your situation. There's no obligation, and sometimes the peace of mind that comes from understanding your options is valuable in itself. You can book a consultation through the link in the description below. Thanks for watching, and I'll see you in the next video.